Welcome, everyone, to this Encore Roadmap Coffee Chat. I'm Janine Vanderburg, CEO of Encore Roadmap, which provides basically consultation to employers about the value of older workers and intergenerational teams. We help older workers, experienced talent, develop businesses based on their expertise. And the other thing that I spend a lot of time doing is fighting age discrimination in the workplace, in public policy. And this coffee chat is in that category of work that we do. So with that, I am thrilled to welcome Gary Phelan, an employment attorney, an adjunct law professor, and someone who's previously chatted with our community about workplace age discrimination and what we can do to stop it. This month, and I'm not sure what is going on, I have personally received so many more direct messages on LinkedIn, emails about, is this workplace discrimination? My boss did this, or I got pushed out, and all of these kind of things. And I invited Gary back, and he was gracious enough to take time out of his really busy schedule and say yes. So, Gary, this is why you're here. I want to welcome you. I also want to note that a few people queued up questions about things that specifically aren't about the legal aspects of workplace age discrimination. So, for example, I did receive some questions over the last 48 hours about what should I do with my resume. We did a program recently about getting hired over age 50 with executive coach Kate Bond, in which we answered a lot of that type of question. And I'll be sharing the link to that recording at the end of this session and also in a follow-up email. So with that, Gary, I want to thank you so much for being here. And before we dive into the very numerous questions that people queued up when they registered, I'd love for you to maybe tell us a little bit about how you came to focus on age discrimination in your work, and really, why does it matter so much to you? Because I know you're very passionate about this.
Oh, well, thanks, Janine, and sorry for the technological scare. I always have faith that something is going to appear, and it did. But I practiced employment law for about 37 years now. And so I've done the wide spectrum of issues relating to employment. Age was certainly part of the practice. Probably what I did more than any other area was disability discrimination, because I teach that at law school. I co-authored a treatise many years ago that I updated on the Americans with Disabilities Act. But I think that I've seen over the past 5-7 years more and more age discrimination cases. What's really had an impact on me, though, is just how unfair, from the standpoint of where often it's not anything relating to performance. It's not where or there's any indication necessarily that their performance decline. It's just all these contrived reasons to justify why they are terminating people, dealing with reductions in force that have a vast disproportionate impact on older workers. And how just stunned, like these are people who have done all the right things. They've worked hard, they've gotten great education, and then they're just like dumbfounded. Like, how did this happen? Still kind of stunned, even more so than other areas of protected classes that I've represented. And what really, it's kind of infuriating. In so many ways, it's like, the more and more where then I'd see they were struggling to just get interviews, people with outstanding resumes, outstanding backgrounds. And it would be so frustrating to say, this is like wasted talent. And so, and I always think, the phrase, the thing that's always had the most impact on me in the area of age discrimination. If you recall, the play, Death of a Salesman, with, Willie Loman. And there's a famous line where, Linda Loman, who's Willie Loman's wife, says, I wrote it down just to make sure, you can't eat the fruit and throw the peel away. A man is not a piece of fruit. That is happening more and more to men and women in the workplace, just being thrown away. And to me, that is such wasted talent, particularly where now there's starting to be a real gap in the talent pool. where employers are saying, hey, we're not getting enough, we want to hire more people. And yet there's so many people in the older ages who aren't not just not aren't getting jobs, aren't even getting interviews. So it's kind of that combination of thing where age has become a lot more a part of my practice.
Yeah. Well, and I really appreciate your focus on this and also your insight. And I actually use the word stupid when I'm talking to employers, which probably, shocks them a little bit when I show up and just say, when you push older people out and you're not bringing younger people in, kind of a stupid long-term talent play. But it really, I think, looking at demographic change, it absolutely doesn't make sense. So I want to kind of level set for a moment for anyone who's joining us today or maybe listening to the recording, and they're worried that something that they've experienced might be age discrimination, but isn't sure. How would you describe in plain terms what workplace age discrimination actually is and who is protected?
Basic definition is who may be protected is anybody over 40. It's covered under the Federal Age Discrimination Employment Act. It prohibits where age is a factor in a employment-related decision. That the burden then would shift to the employer to say it's based on a business-related reason. It's up to the individual to show that that's a pretext, that's a false reason, or it could be a false reason. Where, on the employee side, we're always at an informational disadvantage. So we use what we can. Part of that is also, though, trying to show that age was a part of the decision-making process. There are genuine business-related reasons when they wipe out a full division at a company and there happen to be a good number of older workers in that division. It doesn't necessarily mean it's age discrimination when in fact the division was performing poorly. But the focus again is always on, is there an adverse employment action? The obvious adverse employment action is termination, but also relates to the start of the employment processes, which is in the hiring process. Right. Proving age discrimination in hiring is one of the hardest things to prove in all of employment law.
And we'll dive a little bit into that in just a moment. Somebody queued up a question, and that I want to ask you now, saying basically their feeling was age discrimination is disproportionately experienced by women. In your experience, is that true? And if so, why?
I think it is. Why necessarily? It's hard. I think because they're facing double stereotypes, because at the core of all of discrimination law are stereotypes, whether it's based on race, age, sex, disability. And so women face both the stereotype with respect to age as well as gender. And so I have seen that, seen it. Any studies have shown that it's statistically at higher levels. And I think of certain industries, for example, in the, if you go to, your local TV station, who are the anchors? Often an older gentleman, with gray hair and a younger female reporter. How many local TV news do you see with a older female reporter and a younger male reporter? I can't recall a single time that I've ever seen that. Mm-hmm. And so I think that sort of stereotype, that's just one illustration of kind of the impact I think it has.
Yeah. Well, and it was interesting. Dr. Amy Deal and her colleagues have done some of the studies that you're mentioning. And, their conclusion, I call the Goldilocks syndrome, that women are never the right age. When we're young, it's sort of like too cute and not taken seriously. And would you get the coffee? And then you get to middle age and, well, you're just going to go ahead and, skip out of work to go watch your kid's soccer game. And then all of a sudden we have expiration date on our forehead. So we are never quite right. But thank you for adding some insight into that. So you started speaking about hiring, and that's where I think a lot of people first experienced age discrimination, especially people who've been in a long time position, kind of were pushed out, laid off, whatever happened, they're gone. and now they try to get back in the job market. So can you talk to us a little bit about what are some of the signs in a job posting that indicate older adults need not apply? And what kind of action should someone take if they see a really ageist job posting?
I think more and more the focus is on terminology that has to do with technology. Phrases like digital natives, tech savvy. Also, things about comments like or phrases like high energy, cultural fit. All of those types of statements that sound amorphous, but it's often code for what could be an ageist environment. I think what people do is, what they can do is push back. I say still apply because maybe it isn't that reason. But if you feel like you were very qualified, then follow up, file a claim. We'll get into where, the AI hiring issues with respect to AI hiring, but you don't necessarily to file a claim with a state agency, a discrimination claim, if you think that's a reason in that they were using this code type of language, just file a charge, discrimination claim.
So, and so someone queued up a question that just stunned me. And I was like, oh, please, I hope they haven't actually seen it. And the question was, can an organization overtly advertise that they want to hire people in a range of age groups for a front desk hospitality job? And I would add to that for any job. I'm thinking you can't do that. Am I?
A lot of questions, these are really good questions, but that's one I can answer without having to give the lawyer's answer of, well, it depends. Absolutely not. I can't say that. Now, the only time, there are certain jobs, like they were looking for a teenage actor for a role. Well, that's a different story. If it's what's called a BFOQ, bona fide occupational qualification for that particular job, it's a very narrow scope. But that there are still ageist types of job advertisements that aren't that explicit that certainly imply younger. Something as simple as, you'll often see something like minimal qualifications, 2 years. But then it's like, are there maximum? We only want applicants with 2 to 4 years experience.
Yes.
Well, it's that maximum limit that could be age discrimination. And so, to really drill down exactly what they are looking for in a job advertisement.
Yeah. What about, so I've seen this and I've actually pushed back and written to some companies who say, we're looking for a recent college graduate. Now, I personally had a mother who went back to school, went to college at age 60. So at age 64, she was a recent college graduate. But generally, is that code word for we want someone younger?
I think it could be. Now, courts are often, there aren't that many cases, but I do know cases where courts have said, well, no, they just want somebody who's recently graduated. That's not age because anybody could have just recently graduated. I think on the other hand, because it relates to the question, it's intertwined with age, I think there's a good argument that would be unlawful. And so, but, I don't want to, like many other areas in employment law, what may seem to people like us as age discrimination doesn't necessarily, a state or federal judge doesn't necessarily agree.
Got it. Okay, I want to look at the other side for a moment. For people who are job hunting, are there things that maybe they should be looking for in a job posting that signal kind of the more age-friendly workplaces that are open to hiring people over 40?
I think phrases that imply that they're, a flexible workplace. It's one of the things that I have seen from all the research I've done about is one of the things that older workers tend to want is more flexibility. That's not necessarily, part of that is the ability to work remotely, but also flexibility with respect to hours. That's a positive thing. Others may be where somehow either expressly or implicitly imply that they value experience. Yeah. They value people who can provide mentorship. Separate from what the job ad says is also go to the website. Websites, speak loudly. the pictures on the website of what the workplace is. And I know when I have age discrimination cases, I'll go to the website. And if it looks like happy hour at the local bar, because that's what many of them do, they're diverse, maybe gender-based or race-based, but not age-based. And so those are the sorts of things that I think could indicate in a positive or negative way. If it's more of what appears to be age diverse, that's again a very good sign.
Yeah. No, and I do the same thing. I love looking at websites. So to see, even for people who claim that they're being age friendly, does it really show up in their collateral? So another question that comes up frequently is, once somebody lands in an interview, so let's say you get through whatever kind of hurdles there may be in applying, and you land an interview, how do you spot ageism? What are red flags of questions that might be asked in an interview, and which ones might actually cross into unlawful territory?
It's I don't think, well, the one that I think clearly crosses into unlawful territory are things like, what year did you graduate? Or how long have you been working? Those are, because you can't answer those questions without making a direct reference to age. Those that, and now again, the questions itself aren't necessarily discriminatory. It's what is the action based on that? So it would have to be coupled with not getting an offer, for example. Others relate to I think more and more questions related to your technology use. What types of technology do you use? Sometimes even trying to sort of common technological tools in a workplace, and the often very much younger person doing the interview is explaining it in detail when in fact they know that very well.
Yeah.
The equivalent of mansplaining, but related to age.
Oh, we need to come up with a term for that.
Yeah.
You've just given me a good idea. I'm going to, everybody, if you come up with a term for what Gary just said, go ahead and put it in the chat. There may be a prize involved. Okay, go ahead.
Others, it may be questions like, well, how long do you plan to continue to work? Because again, that's an issue that is believed to hurt older applicants because of the perception that, well, if we hire them, they're going to be retiring in a few years anyway. So why do we want to train them? But what I've encouraged people to do is when you get questions like that, see it as an opportunity to educate. It may end up being evidence of age discrimination, but you may say things like, on that question in particular, I know I follow Colleen Paulson.
Right.
And she's done work how the average length of employment is 3 or 4 years. So, and often older workers stay longer. Right. So use that as a way to educate whoever is asking those questions. So also, and say questions like, this is, this job is not necessarily as big as other jobs. Do you think you're overqualified? Or you think you'll still be challenged by this job? Or perhaps it involves, you're looking at a job that pays less. Do you think you'll be happy with making less money? Those kinds of types of questions may also trigger some sort of ageist bias.
Yeah. Okay. Good insight. So you mentioned earlier AI and hiring. We know that there's a lot of focus on that right now. 2 big lawsuits, one involving Workday and Eightfold, have raised the question of whether hiring algorithms screen out older applicants. And so, in your view, what do these cases tell us about how AI hiring tools can't discriminate by age? And what rights does a job seeker have if they suspect they've been filtered out? So, for example, if they apply for a job online at 2 p.m. and at 2:05, they've received an auto rejection, just say.
I think one of the first things I've encouraged people to do is be creative, because look at, the Workday case came from somebody who said, wait a minute, I'm getting rejected right away, and came up with the creative idea to apply at 1, 2 in the morning, and was still getting automatic rejections. To see are these just being made automatically by AI? Also, for example, the EEOC had a case also in the previous administration, in the Biden administration, that they had filed, where getting back to the age-based bias, it was programmed to screen out any males over 60 and any females over 55.
That was
Well,
ITutor, right? The
yeah,
tutoring. Yeah.
yeah. So how did somebody find out about that? Because you wouldn't necessarily know. A woman changed her age, same application, but changed the date of birth on there and ended up getting an interview. That's what was a catalyst. So think about creative ways. The other is go directly, go to the company and say, hey, I noticed, this didn't, I was screened down after 5 minutes. Did any human do this? And are there any alternatives for me to seek employment? Now that this issue has been highlighted, I think you're starting to see some impact of where at least companies are aware of this. They may or may not have been aware before, but I think they are now, particularly because of the coverage of the Workday case. Unfortunately, federal government not doing anything about this, even though it's so important. At least through January 2029, we're not going to see anything on the federal level. States are really starting to address this. States like Connecticut, there's now, I think, 6 states that have adopted regulations relating to hiring. For example, in Connecticut, a recently passed legislation that goes into effect, it takes away what's called like the AI defense, where employers may argue, hey, it wasn't us. That was just the AI tool. You can't use that anymore. Good. So so I think things are happening on the state-wide level, but also there's always the option of just filing a charge with I would focus on state claim, because the other problem with these types of cases, they're often going to be disparate impact cases, not disparate treatment.
Tell us what that means. Wait, stop, Gary. We have not lawyers here. What does disparate impact mean?
Disparate impact is where there's the employer's not necessarily intentionally discriminating, but it has a discriminatory effect. Okay. Why that's become very important is the Federal Equal Employment Opportunity Commission is now not litigating disparate impact cases. And so where it often happens, for example, with respect to reductions in force, where it has a very disproportionate impact on older workers, but there's no evidence to say, where they specifically chose older workers in order to target. So that's why it's a very important concept. It's still illegal. Just because this federal EEOC isn't litigating disparate impact cases doesn't mean it's not still unlawful. I mean, the U.S. Supreme Court says this is unlawful discrimination. So with the AI tools, because so much of what the AI tools use is just the historical data from the employer, and if those numbers reflect a disproportionate younger impact, it's going to show up in their hiring, who they're hiring, who they're interviewing. It's not those are disparate impact types of cases.
Okay, so the fact that for right now the EEOC isn't pursuing those cases doesn't mean that someone shouldn't try to do something about it. Is that what I'm hearing?
Absolutely.
Okay.
Yep.
I want to switch now to ageism on the job. We got a bunch of questions on this, and that was actually one of the things that triggered me reaching out to you, Gary. Those kind of like comments that you get when you're or the kind of behavior that all of a sudden people are treating you with. One person who registered shared this experience. Had a manager at work called me old, steady Eddie. What should someone do when a supervisor or a coworker makes remarks like that about their age?
You know what? I think that, the phrase of where you have to pick and choose your battles. And if this is a coworker, it may be they really don't necessarily intend anything negative about it. But if it bothers you, speak to them, and speak to them privately, not in front of others. Context is also important. In what manner are the statements being used? Is it being where it's tied to negative performance, or you're clueless when it comes to technology or something where they're being criticized for their work. If it's tied to age-based stereotypes as opposed to just kind of a comment like that one, that's when I think you have to stick up for yourself. The other thing is document it, because it may not be having an impact right now, but it might down the road. And so keep a record of it. And where it's very important is if those kinds of statements are being made where someone in a managerial capacity, particularly if they're made during a performance review, let's say, or whether, you're being informed about whether or not you got a raise or a bonus. That's where those sorts of statements may be very good, both indications that you may be sort of on the target list, but also evidence of age discrimination.
Okay, so building on that, let's talk about maybe some other kind of comments that may cross the line into age discrimination. So for example, I've had people tell me that, someone keeps popping by their desk and saying, aren't you going to retire yet? Or don't you want to spend time with your grandkids? Or if they are applying to get into what the latest professional development is around new tech that the company has adopted, really, you want to learn that? Or are you going to stick around that long? What kind of comments actually cross the line into age discrimination and become legally significant?
When courts generally will look at, as I was saying before about the context, if they're sporadic comments, not real questions like, when are you going to retire? If they're comments relating to, like planning, succession planning, many courts will say, well, that's not necessarily unlawful. Where they start to trigger legal issues depends on who's making these comments. Is this a coworker who you've known for 10 years? And, you're talking about your grandkids and they ask a question like that? Or is this a manager who you don't really have that much of a friendly relationship with? So it's not necessarily out of curiosity. Where it definitely raises legal issues is if the person is asked either when or are you going to retire, and responds saying no, or I have no plans, and those questions keep coming. And that's that's where I've seen cases, and I'll be briefing, a case like that in a few weeks, where they come up not necessarily just in passing, but at critical times, such as when they're doing an annual performance review. And it often also comes with implicit threats. And where it's particularly where the questions are coupled with action.
So can you give us an example of that, Gary?
Sure. Where somebody is asked about when you plan to retire. Well, I have no plans. Oh, and then shortly after, a younger employee is well, we're going to give this to, we're going to get we want to start breaking in Joe into this particular leadership role. And they held the leadership role. So they're being replaced in that leadership role. Little things that start to become bigger things. A prize case, client, assignment, all of a sudden given to someone who reports to the individual being asked about retirement. All of a sudden not being asked to meetings that others are going to. Yeah. So but tied to action, but also, the repeated types of questions, because it's a way to, is strongly suggesting that you might want to retire. There is a case in Connecticut where this was a case against IBM, where a 61-year-old manager said he didn't want to retire. He was repeatedly asked. Then he was reorganized. Then he was terminated. A jury awarded $2.5 million on his age discrimination case. So the context of when those statements are made, is it in passing? Is it after the person says, I don't really have any plans to retire? That's where those types of cases are very important.
Okay. So you've kind of started touching on this. Someone else asked a question about their duties being handed off to others. And in this case, someone 10 to 15 years younger. Is in and of itself reassigning an older worker's responsibility to younger colleagues a form of age discrimination? And how does someone prove something like that?
Well, it can be a form of age discrimination because, and if that were the case, I think what I'd recommend is ask, why did this happen? For the employee to ask, not just look the other way. Particularly where you see this most often is in cases where there's reductions in force, where somebody is told, like an employee case I was working on this morning, we're outsourcing your work to India. Turns out she's not been there 3 weeks, and they didn't outsource, so they were outsourced some to India, but gave most of her duties to people who are 10 and 15 years younger. 10 is important because what the U.S. Supreme Court has said is significantly younger. And significant, at least where I am within the Second Circuit Court of Appeals, is generally from 8 to 10 years younger.
Okay.
Often, the question is, why are those duties being reassigned? And what often was the case in the past is, well, if the person whose job duties might be reassigned, or some of their job duties, if they didn't get a pay cut, they didn't get demoted, then there's no adverse job action. Whereas now, after a major Supreme Court case in 2024, the definition of what is an adverse employment action is expanded to really some harm. It doesn't have to be substantial harm. And so, okay, as a result of that, what is the impact? Has now that place really limited their promotional opportunities? Is it limited their potential for a bonus? Are there other impacts other than just the fact that their salary wasn't reduced?
Yeah.
So, but that is, usually things aren't reassigned to younger workers unless there's a reason.
Yeah.
And it's important to find out what that reason is.
And so, Gary, George just put a really interesting comment in the chat. And George, I hope you don't mind my reading this. I was saying he was on a, quote, mature sales team that was told the company is, quote, younging down to hire more early career staff. Isn't that a dumb thing for a company to do?
Comments like that, though, make my job a heck of a lot easier.
To go, whoa.
Because it reminds me once at a case where the company had a mission statement that said one of their missions over the next 5 years was to reduce the average age of the salaried workforce. You don't see evidence like that much, but statements like that are blatant age discrimination. And unlike other areas, there still is the ageist types of direct comments sometimes happen more and more, particularly where they're intertwined with retirement. Like a case I did where the CEO was 63 and said, you know what, I think I'm going to retire. I can't do what I used to do. And I think it's time you retire too, to my client who's 61. And he had never even asked about retirement. But so that would be pretty direct age discrimination.
Okay, George, you heard it directly from Gary. Somebody else asked a question about because very often people are encouraged to take their complaints to HR. What do you do when HR isn't helping? And in fact, complaining to HR leads to retaliation.
The one thing I always remind people is HR does not sign your paycheck. They are not there for employee. They're there to problem solve. And I've represented people in HR, and many of them are very much want to resolve problems and want to don't like it when employees are discriminated against. But ultimately, their job is to protect the employer. And so when clients tell me about their thinking of going to HR, I said it may be helpful, and sometimes you have to. For example, in certain areas, you're really required to try to resolve it internally, and sometimes it does get resolved internally. Oh, but go there knowing there's a risk of retaliation. That's why what I will usually encourage clients to do is whatever you're going to do, whether you meet in person, is have documentation of that, whether it's by email, because then becomes a case of, is there a retaliation case, depending on what happens. Timing is everything in retaliation cases. So, but as long as you're willing to accept the risk then I think that, you still try to resolve the problem if you want to continue to work there, but just accept the fact that there's always a risk of retaliation.
You bet. Okay, I want to switch topics for a moment because my least favorite Yale professor, Samuel Moy, has written several articles and recently published a book calling for, among other ageist and horrendous things, mandatory retirement. Basically says older adults should be pushed out of the workforce. Are mandatory retirement policies actually legal, and are there exceptions? What should someone do if they feel like they are being pushed toward a forced retirement age? That was a long-winded question.
Yes.
I need a short answer because I have so many more questions to ask you.
There are some jobs that do have mandatory retirement ages. To a large extent, they've been kind of eviscerated as clear-cut age discrimination. Now, like commercial airline pilots, the FAA has a 65-year-old maximum. Air traffic controllers, 56. Law enforcement officers, there's often an age limit. State court judges, for example, in Connecticut, it's 70. Where there are within professions, there are often mandatory retirement policies, for example, big law firms. But those are partners, so they're not necessarily employees. There's certainly a dispute of, are they a real partner or are they a non-equity partner? But by and large, mandatory retirement policies are unenforceable, but that doesn't mean we're not going to start to see it. And it's not just the gerontocracy in America, I think, is
Gerontocracy in America.
Referred.
Yeah.
I think you're going to see those kinds of topics start to be discussed more often. Where we're starting to definitely see it is in the political arena, with respect to different, that there should be age limits for presidents or people in Congress or something like that. So, but generally speaking, they're unlawful, and because they're clear age-based discrimination.
So let's talk about another issue that's been rising more and more lately, and that is cognitive testing. We're hearing more about employers using cognitive or fitness testing. And when is that legit, whether a pretext for pushing older workers out? And what kind of rights does an employee have if we're asked to take one?
Well, very good timing, because tomorrow, the most important cognitive testing case pending in the country is going to be argued U.S. District Court in Bridgeport. It's a case called EEOC versus Yale New Haven Hospital, and it's a case that was actually filed in 2020. Yale has what's called a late career practitioner policy, where once you turn 70, every 2 years, there's a mandatory cognitive test where all physicians are required to take a cognitive test. I believe 14% of those tested had some indication of some cognitive impairment. They may be pushed into, where they can't work anymore, or maybe depends on, they might be reassigned to teach. But the EEOC filed suit in the Biden, or that was the, might have even been in the Trump administration, but the case is, there's arguments on both sides with, where you're combining patient safety, but also stereotypes in effect. And it's a case both for age discrimination as well as perceived disability discrimination by the fact that you are requiring just people over 70. First, that's age-based. Secondly, is you're essentially forcing the physician to prove that he or she is fit. So you're perceiving them as almost having a cognitive impairment unless they can disprove it through testing. So when the first time I did a panel discussion where I teach as an adjunct Quinnipiac Law School, that was really the first time I heard of it. And it was, about this case. I said, if this is found to be lawful, don't think that it's only going to be the medical profession where we see it. We're going to see it in law firms. We're going to see it in colleges and universities and teaching and other arenas. And the next day after that was when, one of the candidates in the Republican Party Nikki Haley proposed a age limit on people running for president of 75 years old. But I think, because of the technological tools are being both more sophisticated as well as less expensive, I think this case is really right on the cutting edge of what we're going to see more and more often.
Right.
And a lot of it, I think what'll happen, I think whichever way the judge rules, I anticipate it's going to be appealed to the Second Circuit. What I have heard is the healthcare industry has been like waiting for this, because if it's found to be lawful, you're going to see a surge in the healthcare industry of these types of tests. And then when that becomes much more, if it becomes more common, you'll see it start to spread to other industries.
Well, and again, ironic considering the shortage that we have overall of talent in the healthcare industry. But there you go. Okay, we've only got 15 minutes left, and I've got some really big questions. So we're going to go really fast. A quick one, I hope. Do governments have immunity from the Age Discrimination and Employment Act, the federal law?
Yes, governments have, state governments, not local governments. State governments have immunity under the 11th Amendment, but you can still pursue claims. Overwhelmingly, most states have waived their sovereign immunity, so you can sue them under the state anti-discrimination law.
Okay. Non-disclosure agreement. So I have heard from several older workers who've reported being asked to sign an NDA, often tied to a severance or a settlement, so a non-disclosure agreement. What should someone understand before they sign one? And can an NDA stop them from reporting or talking about the age discrimination they experienced?
Generally, NDAs have been upheld because, for example, with a severance, it is, a contract. So the employer will, I think they're more common than not. They're pretty much routine. Now, there has started to be a pushback of confidentiality requirements in severance agreements. What you can,
sample set. Man, it feels.
Can I ask everyone to mute themselves, please? Thank you.
So one thing you can try to do is negotiate it down. For example, I've done that where, there's been a confidentiality agreement saying you can't discuss anything you've ever said. There's also non-disparagement agreements. I don't think, I would never advise a client to say, I can't discuss my employment generally, but it's fairly common to say you can't disparage the employer as part of a severance agreement.
Okay. Let's talk a little bit more about severance. I know that's something you're well versed in. If someone is terminated and offered a severance agreement, should they try to negotiate for a higher severance? And why might an employer increase its severance offer? And I guess overall, Gary, what advice do you have for someone if they're in the situation of negotiating a severance? Because it's also a fraught time, right? You're like,
Right.
God, I'm losing my job. What advice do you have?
First thing to do is to kind of be patient as much as it's frustrating, because a lot of times, when people contact me, they're panicking, particularly if it came out of left field. One is to see could there be any age or other types of discrimination claims? Now, one of the things, for example, when there's a reduction in force under the Older Workers Benefits Protection Act, the employer is required to provide the ages and job titles of those kept on and those let go. So you'll see whether or not age was may have been a factor. It's not definitive, but it gives you some guidance. But if you're an individual and you think age was a factor, I have always recommended that people go to an attorney, and it may be just first to get advice. I mean, the employer has lawyers routinely that drafted those agreements to get advice just on what they're agreeing to do. Things like NDAs, where people may not really understand them. Because the best negotiating leverage you may have to negotiate for an enhanced severance is the possibility of legal claims. Now, as I talked about before, you don't know all that the employer knows, but you may have evidence that might support a claim of age discrimination. Make a counteroffer. Not just say, what I always discourage people from doing is going to the employer and saying, is that flexible or something along those lines. Have a definitive counter, at least realistic. based on whatever the negotiating leverage is. Let's say you really don't think you have any negotiating leverage. There's goodwill. For long-term employees, there may be people who are in the management roles who, they're close friends with. There may be empathy. Use whatever you have as negotiating leverage. But what's also important is not to, I always say to clients, like, that I'm going into a meeting and I think I'm going to be terminated. What should I do? It's more what not to do. Don't get angry. Don't make accusations. Ask questions, like, why was I terminated? Because that's often, down the road, if something's not resolved, there may be indications of that was a false reason. But to still be, professional, but also not necessarily to rush into anything. Patience is important. It's when I teach negotiation. Impatience is a weakness in negotiating. So be patient. Use the time you have, whether it's 21 days, if it's an individual termination, 45 days, if it's a group termination. Use that time. Try to maximize your leverage, and also seriously consider having it reviewed by an attorney.
Okay. I want to go to another. What do you do if your employer has a mandatory arbitration agreement? And I know there's currently legislation somewhere in Congress to kind of eliminate that, but right now many employers do have mandatory arbitration. What do you do?
Well, you're stuck. I mean, the Supreme Court has really given the green light to mandatory arbitration agreements. It's very, very hard to try to avoid a mandatory arbitration agreement. Now, the practical reality is that does limit your leverage. The arbitration process has gotten better for employees. You often have, more and more people who do what I do, representing employees, are becoming arbitrators. I'm now an arbitrator with the American Arbitration Association, of someone who can take cases with AAA, but there's a real push to try to make it more diverse, and also to get more employee representatives doing that. But you also still have an opportunity to try to negotiate some kind of severance. It's harder to win for employees to win in arbitration. And I think it's also harder to, if you do win, chances are things like emotional distress damages are not what they're going to be for a jury. There are some advantages to arbitration. It's quicker. It's less expensive. Also, some employers have what are called mediation and arbitration. Utilize the mediation process also through that mandatory arbitration agreement. But if and when they've been eliminated, mandatory arbitration in the federal government, or by the federal government, in sex harassment cases, and so that may happen at the federal level. I don't think it happens in this Congress.
Okay. So a big question I think that has come up from a number of people is, when is it actually worth it to sue? And is it? I mean, people have heard these cases take so long. How much money is it going to cost? And I personally know a number of people who are afraid of doing that because they're afraid if they engage in a lawsuit, file a complaint, that there's a stigma attached and they will never work again. Talk us through that. And I'm giving you 2 minutes because then I've got some really important other questions to ask you about hiring an attorney.
I think this is something where you definitely do need to consult with an attorney. There are pros and cons. Certainly that's where you maximize your leverage. I think one of the most important things that is to try to use mediation. You can resolve a case without filing anything in court to see if both sides agree to mediation. The most effective way to resolve cases, if both parties agree. Mediation tends to result in settlements in the employment law arena about 85% of the time. Obviously, if you're going to file a lawsuit, it's important to have strong evidence of age discrimination. But also, most cases never get to a courtroom. They're filed with an agency. Utilize the agency process. Usually with agencies, they do some investigation, and they will then have often a mandatory mediation. Mandatory, not as good as if it's voluntary, but then utilize every opportunity to resolve cases along the road. Age discrimination cases, it's not just the financial cost, it's the toll it takes emotionally. And it is something that, as I have to tell my clients, particularly if it's filed in court, you can Google it. and you'll be able, a potential employer will be able to see it.
Yeah. Okay. So we received a bunch of questions, and I'm going to consolidate it into one long question about when should someone hire an attorney? How do you find an attorney experienced in employment law? What do employment attorneys usually charge? Do lawyers provide a free consult to see if the case is worth pursuing? I think people get paralyzed, even people who feel that perhaps they have a strong case get paralyzed by the whole process. What's your advice?
First is when reaching out to an attorney, that's an important threshold question to ask. Do you do free consultations? Most experienced employment lawyers do not do free consultations. Some do. As far as finding a lawyer, I always recommend that people contact the National Employment Lawyers Association or go to their website, which is www.nele.org. It's a national organization of probably about 3,000 or so lawyers who do employee side employment law, at least 50% of their practice. I always think you're entering into a contract. And so even if nothing else, for a 1-hour consultation to understand the contract, to assess whether or not they're legal claims, I think it's very important to do so. One of the other things, if you feel like you have negotiating leverage, particularly if there's age-based evidence, definitely go to an employer, because you don't want to be negotiating because you're really not going to have credibility using that as leverage where you don't have a lawyer. Employer may think, oh, they couldn't find the lawyer. That's why they're doing this, do it
Right.
yourself. So
Okay, I just want to make sure I understand. So you're advising that you would actually bring the attorney in as part of the negotiation. Is that right?
it depends.
Okay.
If there are genuine claims, if, for example, when I advise a client, if I don't think they're genuine claims, but I think they had a long career, they have a lot of goodwill, I'll advise them behind the scenes.
Got
Because
it.
I think when you bring in the lawyer, the other side's going to have lawyers. And so the other side, they're going to be looking at what is our legal exposure here. If there are no genuine legal claims, I don't think it's always a good idea to have a lawyer doing the negotiations.
Okay, good advice. I've got a final closing question for you, and then I'm going to let everybody know what you are getting after this session, what will be sent out. Gary, as we wrap up, if there's one thing you would want every worker, job seeker, age 40 and older to know about their rights, the single most important takeaway from today, what would it be?
I think it's joining with others, participating with others. When I'm teaching disability law this semester at law school, and we just covered the history of the disability rights movement. Disability rights groups were all separated into different groups. When they came together, they had power. We're starting to see that now with respect to age discrimination. People like you who are leading the fight. And that's why in one of your columns, you talked about, Sheila Callahan and Forbes saying this is kind of the year of age bias.
Yeah.
There is now a need in the workplace for more experienced workers. I think in many ways with AI, qualities like experience are going to become more important, not less important. And so, but there's individually, we're fighting individual battles. It's much harder when
Right.
you collectively, not only with respect to pushing back, but educating
Right.
by talking about things like Becky Levy's, research at also at Yale, about how positive attitudes with respect to aging are having negative attitudes take a huge health toll. And really seeing this as an opportunity to change the playing field for older workers, because there's never been more of a need for older workers than there is now.
I could not agree. You are singing my song, Gary. Thank you so much. Everyone, if you can unmute yourself and just give Gary a huge round of applause. Okay, you actually have permission to unmute. Gary, thank you so much for sharing your wisdom. I know how valuable your professional time is. Here's what I'll be sending out, everyone. I'll be sending out an edited recording of this, and this will probably go out on Monday with some additional resources, both that Gary has mentioned that some of you put in the chat. I agree with Gary that the time is now. One of the things that I am involved with a group of other organizations across the country is making Congress and elected officials pay attention to workplace age discrimination. When you hear elected officials talk, people are talking about gas prices and they're talking about grocery prices, and that is lovely, but they're not talking about an issue that affects so many of us. So I'll also be sending you information to join that campaign. We plan to make a lot of noise about it, including on a specific day, October 9th, Ageism Awareness Day. Thank you for being with us. Thank you, Gary, again, my friend. I really
Janine.
appreciate your insight. Have a lovely rest of the week, everyone. Happy Hump Day. Bye.
Bye.